Hafaday. Hafaday, thank you everyone for being here today. We're going to begin this hearing. We've got a lot of people here, so let's get started. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. It's about 5:05 p.m. Today's Thursday, November 7, 2019. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Tuesday, October 29, and again on November 5th, 2019. The notice was also published in the Guam Daily Post on Friday, October 31, and Tuesday, November 5th. The agenda item is, this is our third informational briefing on Guam's Medical Malpractice Mandatory Arbitration Act, which is contained in Chapter 10 of Title 10, Guam Code Annotated. We wanted to concentrate in this third hearing, or this third briefing, on options going forward, and there have been many suggestions, so we'd like to just take a very brief review of that. There's additional testimony that some people would like to provide tonight, and recommendations for improvement of our Mandatory Medical Arbitration Act. The committee is particularly interested in whether the law can be improved to better protect patients and to ensure an appropriate standard of care. Suggestions for reform or arguments against reform will be heard and considered. The goal of the committee is to hear and gather these arguments in order to allow all the senators to fully consider any changes and impacts of changes to the current law. At our first informational hearing held on September 19th, the public was provided with a basic background of the malpractice law and the Government Claims Act as it relates to claims against government medical professionals. At the second informational hearing held on October 3rd, health professionals testified to the impacts of the current law on their current practice and the standard of care on Guam. Testimony was also provided on the possible impact of prospective reform to the by several, including Attorney Robert Keogh and Attorney Mitch Thompson. Some attorneys and testified at several hearings on the experience that, including Attorney Bell, as to their experience representing claimants. And of course, we've had some claimants who have testified directly regarding their own experiences. I prepared a very short spreadsheet. My staff prepared this pretty much just to summarize the concepts that have been put out there, or recommendations, and but we are going to continue to hear some of these tonight. All of the testimony will be compiled. It's going to be put up on our website. It will be sent to the Speaker of the Legislature in a report so that all senators will have access to every document that has been submitted to me and all of the recommendations that you have made. As we said earlier in other hearings, this hearing is not considering any particular amendment. That amendment would have to be made in a bill form, and it would have to have its own hearing and testimony from the public. So to begin, I'd like to, if I could get the sign-in sheet. I'd like to recognize the presence of my colleague, Senator Terlaje. She's been here at every hearing. Thank you very much, Senator. Okay, so we've got quite a few people who've signed in, but to give oral testimony, we have Mr. Lepofsky, if you could have a seat. We have Dr. De Guzman and Maria De Guzman. Mamie Balahaja, Dr. Balahaja? Okay, and Oh, I see. No, sorry. Therese Underwood. Alfredo Bustamante. Mo Ping Tam. Dr. Alfred. And Attorney Thompson. So according to the sign-in sheets, no one else is here to present oral testimony, and so we'll listen to this testimony and then we'll proceed with Stan Yasuhiro. All right. Mr. Lepofsky, is it okay if I ask you to keep your testimony to 5 minutes? And we will allow everyone to talk, and then we also want to put on the table all the proposals that have been made, if that's okay. Please proceed.
Good afternoon, Senators. Thank you for allowing me to give testimony again. My name is David Lepofsky. As you know, I'm the father of Asher Dean Lepofsky. And I'm here, as I said in the last meetings, to give a voice to my son and the hundreds of people on Guam that have died or have been injured due to negligent medical care that continues to go unaccounted for. I have some recommendations to make regarding new laws and regarding arbitration, but I'll do that later on. I want to make some points first. In the last meeting, I want to touch upon this, please. Dr. Berg, the chairperson of the Guam Medical Board of Examiners, implied public policy should not be changed based on the death of one child. That statement alone should worry all of us, as it comes from either being uninformed or wanting to hide the truth of what arbitration has done to the people of Guam. Sure, I have been verbal, and Asher has given a face to the apathetic Arbitration Act that kills and hides. But I would venture to say, based on national statistics as presented in the last meeting, that there are thousands of people over the last 30 years that can attest to loss or injury of family members due to medical negligence, not to mention the dumbing down of medical care on Guam. For me, it's a no-brainer, and for the folks that I speak to outside, it seems they all understand that. The most important thing we can do for health care on Guam is to repeal the Arbitration Act and allow people to go directly to court and figure things out. That's my opinion, and simply put, what I think should happen. Let the courts figure it out, allow due process, our constitutional right. With that said, it's probably unlikely that will happen, as negligence has been rewarded over the years, and it's hard to change mindsets. So I concede. Alternatives are important to impact change, and that will benefit the island and protect us from negligent doctors. In any case, with any new law, there should never be such secrecy as we now see in the process. We already have a law in the book called the Patient Protection Through Information Act. This is all about a physician's profile being public information so we can know who these doctors are, complaints against them, and make informed decisions as consumers of health care. This is a law that has been ignored for 8 years, especially by the Guam Board of Medical Examiners, who is charged to implement the law. It should have been on their website for years. Guam needs an open malpractice system that is not hidden behind closed doors, that protects the citizens with the goal of improving health care. Open information leads to decisions by all of us as to where we want to take our family members. If doctors want to hide what they have done and threaten to leave using arbitration as an excuse, let them go. We look for quality, not quantity. With that said, at the last meeting, I did not hear one doctor say they would leave Guam. One doctor said, if insurance got too expensive, he may consider leaving. Well, after all these years, doctors have paid one of the lowest malpractice premiums in the country. So being realistic, there may be increases. Why else would doctors leave Guam? Doctors on Guam are some of the highest paid in the country. Yes, doctors on Guam are some of the highest paid in the country. This little known fact brings doctors here, makes recruiting easier in contrast to what some have said, and keeps doctors here once they arrive. I have references to that in my paper. This is important info, and I'm telling you, doctors should be paid well, very well. But when they say they may leave or malpractice insurance may get too high in Guam, their counterparts in the USA are earning less on average and are paying much more for malpractice insurance. So, if anyone wants to leave, it will not be due to arbitration repeal or salary or income. It may be due to a history of negligence that will become a public record when arbitration is repealed. Actually, this info gives credence to the fact that it's really easier to recruit for Guam than our doctor friends want to let on. According to one doctor, a friend of mine, he said it's easy to get doctors to come to Guam these days with the internet, information available, high salaries, and ease of getting licensed under Dr. Berg and the Board of Medical Examiners. Anyway, we are here today to figure out where to go from here and how to resolve the deadly crisis created by the Arbitration Act. And what I see is the related demise of medical care on the island. I have read the laws over in most states, especially Massachusetts and Hawaii. And I have spoken to doctors here on Guam and so forth. Let me first state emphatically, though, it's still my opinion, as stated earlier, that the Arbitration Act should be outright repealed and all cases go directly to court. I did come up with an alternative, if I can indulge you. First of all, the alternative would be is to allow 3 years to file a malpractice case, as in most places, not the 1 year that we have now. Once the case is filed, a 6-month cooling off period should begin, in which two things should happen. One, the claimant and defendant would submit their claims to an off-island organization like Mountain Pacific Quality Health, which I'm told has served Guam before. They would be tasked to look at the issues and make recommendations to help improve overall care on Guam and to help make our community healthier and to ultimately lower health care costs. They could compile info and look at trends on Guam, such as problems at a certain neonatal ward or issues that repeat themselves over and over again at certain clinics or at the hospital, and make recommendations for improvement. They are off-island, so that it will not be the local inherent bias that has been discussed and mentioned as an example by Attorney Mitch Thompson during our first meeting. This organization or a similar organization can do a peer review of the malpractice claim or any complaints that the Board of Examiners receives regarding doctors. The second thing to happen in the 6-month cooling off period would be mediation. Mediation should happen during the 6-month period, but it's not mandatory. The information from the peer review, which I just mentioned, can be used during the mediation for discussion and try to resolve cases before they go to the next step. All costs are the responsibility of either the doctors, clinics, or it can be covered by a fund that's set up. Claimants or defendants can waive mediation. At the end of the 6 months, if the case is not resolved through attempted mediation, then parties should be allowed to proceed to court via a conciliation process. This is very similar to what Hawaii does. Medical Inquiry and Conciliation Panel, MICP, similar in Hawaii. Before a medical malpractice lawsuit can be filed in court, it requires that the proposed plaintiff submit an inquiry to a Medical Inquiry and Conciliation Panel, consisting of one attorney and one properly licensed physician. Again, in my opinion, which should not be from Guam, should be an off-island person. The inquiry, as similar in Hawaii, must include several factors. The facts on the lawsuit will be based, the names of healthcare providers, and so forth. After receiving the inquiry, giving notice to all named care providers, and so forth, the panel sets a date to consider all evidence, review the medical records, and hear from witnesses. The panel then issues a review of information decision. This info cannot be used in court, but this decision should not prevent court. The goal of the MICP process is to provide non-adverse review of claims by patients and their families to facilitate the conveyance of information without assignment or blame. When the parties are not able to resolve their dispute, the MICP process attempts to narrow and define the claims and to address questions of causation, liability, and damages in order to help the parties better understand the nature of the claims and to help and encourage them to reach a voluntary solution. Statements made during the course of the MICP process and any recommendations made as a result of that process are not admissible in the later court proceedings. The proceedings is not closed to others unless both parties agree. The information in step 1 that I mentioned from the peer review can be included in the MICP process. If the parties cannot come to an agreement, a court case is allowed. I also touched upon financial caps, economic caps, and so forth. Do you want me to?
Just read the topics. We're
Okay.
already at, way beyond the 5 minutes.
Okay, I'm
Just
sorry.
read the topics and we will,
Okay. Anyways, financial caps.
All right.
There should be no economic caps under any circumstances. Taxpayers are not responsible for doctors' mistakes.
no caps.
No caps.
All right.
Economic caps.
Yes, okay.
Non-economic caps should be set at a certain amount.
Yes.
I put down, and that's here in my
Okay.
paperwork.
Yeah, we just want a list right now.
Okay. Legal fees, I covered that. Collateral source rule, I covered that. Punitive remedies, and so forth, and I covered that as well. And again, I reiterated the Patient Protection Through Information Act, which is already Guam law, should be
Yes.
put on the website and should be enforced immediately. And pretty much that's all with my time limit. And
Appreciate that. If we could get a copy, I'd appreciate that, and we will make sure we
Thank you, Senator.
provide that to all the senators. And as to the information on the website, yeah, I've been following up with that, and that should be up to par very soon. So I know, and you were right. It should have been up there. Some of this information should be there. The new law that increases what's going to be put on the website has to be followed through. And I think the health licensing office is trying to do this to get websites up for all of them that are consistent with the requirements of the law. So thank you very much, Mr. Lepofsky. Doctor?
Hi, my name is Dr. Therese Underwood. I've been on Guam since 2013. In 2017, I opened up my private practice, Center for Women's Health, and I'm a OB-GYN doctor. I'm board certified. When I opened up my practice, there was no assistance in opening the practice, okay? It was just me and my husband. There's no hospital income guarantee like in the States where they help set you up and you spend your time paying it back by serving the community. Everything is out of my own pocket, a little bit loans that we're paying back to the bank, okay? It's hard to practice on Guam here, okay? The reimbursements are dismally low. I'm not making a lot of money, okay? So we don't make a lot of money here in general, at least OB-GYNs, okay? My Medicaid reimbursements, I have over $50,000 in delinquent payments, okay? The GRT, not very helpful. It's actually quite painful. Because of that, we have to offer less services to patients, okay? Medicaid patients are not offered long-acting reversible contraceptives because we're reimbursed invoice price. And then it takes 6 to 12 months to get reimbursed, and then we have to turn around and pay 5% of a $1,000 device to the government. We can't afford to practice losing 5% of a birth control, okay? So we're not making a lot of money. It's very difficult to be an OB-GYN on Guam here. Half my patients, more than half, are obstetrics patients, which means I don't bill for their delivery until they actually deliver. So I'm taking care of them for months and with no payment, okay? And for GYN reimbursement, it's awful, okay? If they had a well woman visit, but they had an annual physical, I don't get paid for that. I end up finding out later that they had a physical and I have to bill the patient now, but they're out of my office. So how do I get reimbursed after that? Okay? It's very hard here. If you repeal the arbitration law and there's no protection for doctors, the caps aren't set, okay? One lawsuit can bankrupt me, okay? Malpractice for OB-GYN is almost $50,000 a year. I was quoted $47,000 last year, okay? I can't afford that and to practice here, okay? I would be forced to close my office and leave Guam, okay? There's a shortage of OB-GYNs here. There's a shortage all over the U.S. By the way, Dr. Jensen at SDA is leaving at the end of the year. Dr. Beeling is going to retire from being an OB hospitalist. A midwife is leaving on Friday. We're losing providers for women's health care here, okay? If there's no protection for doctors here, I won't be able to afford to practice here paying such high malpractice rates, which are going to get higher. I will end up leaving, and so will other doctors. And you're wrong. A lot of doctors don't want to come here, okay? And there will be testimony on how hard it is to recruit a doctor here. It's very hard, okay? Many doctors have tried to find partners here, and they haven't been successful for many years. There are a lot of good doctors here. Most of the OB-GYNs practicing in private practice are boarded, which means we have to follow a standard of care. We have to keep up maintenance of certification, okay? I'm a very good doctor, but some patients get mad at me, okay? It just takes one lawsuit to completely tear down a practice. We can't afford to keep losing doctors. We're not getting a lot of specialists here. So taking this arbitration law away and not giving us any kind of protection is going to harm Guam. It's going to limit access to care here. We're going to be moving backwards, okay? So that's all I got to say.
Thank you, Doctor. Senator Taitigui.
Thank you. Thank you, Dr. Underwood, for being here. Where did you practice before?
I spent 11 years in private practice in the States. I
state?
graduated from, well, I practiced in Texas. For a
Texas.
few
And what are
years,
the
and-
arbitration laws in Texas?
Well, they have, I don't know about arbitration law, but I
Or
know they
the-
have tort reform
Tort
there.
reform.
And we don't have anything like that here.
Tort reform. So of course, here it's really helping the doctors quite a bit here on Guam, the current law right now. So you were in Texas, and the tort reform in Texas, was that very,
I believe it's worked out pretty well. I mean, Texas is where a lot of doctors are trying to flood to. I know my malpractice there was only about $21,000 a year. Okay, it actually got less the longer I practiced, and I stayed, clean.
was there a limit to the liability or the
I think
cap?
it was.
Was there a cap?
I think there was a cap, right? 200,000, 250, 250.
250
My
cap?
husband's the numbers man, so.
Okay, so if that's the case, and the cost of, so you're saying that if you were to leave Guam, which you said you will leave Guam if,
Yeah,
if the law
I
changes?
cannot financially afford to stay here. There's no incentive. I mean, we have even commercial insurance payments. I haven't been paid for deliveries from commercial insurance for deliveries I did in July. And there's nobody enforcing the 12% interest we're supposed to be able to collect for delinquent payments.
Well, okay.
It's bad here, guys. There's nobody, we had to stop taking Medicare
Why-
patients because there's nobody to help us with unpaid claims for Medicare.
So why did you come to Guam?
Well, I signed up to do locum work for 2 years with a multi-specialty company, and I liked it. I like to travel here. The weather's great. We don't like cold. So that's why we stayed. There was a need here, okay? And we like the patients, but if it's financially unsound, we can't stay open. Okay, I'm paying myself half as much as what I made at FHP Clinic, okay? And by the way, FHP, their base salary when I started there, started at $15,000 less than what I would have been offered in Washington State when I interviewed there. So it's not like we're making a lot of money here. Private practice doctors, they either have to love it here because financially there's not that much of an incentive.
So, so let me get this straight. You're not happy with a lot of issues here on Guam, especially with reimbursement. It's very hard for you to make a living here, but you're still here.
Yes.
Okay.
I still believe that I can survive. I don't need to make a lot of money, but I'm not willing to eat a loss.
Thank you, Dr. Underwood. Doctor?
Good evening, Senator Terlaje and Senator Terlaje. My name is Alfredo Bustamante. The reason I am here today is to raise my concern as a Guam resident, a U.S. veteran, an animal lover, and as a business owner. I am here to speak on behalf of many that cannot be present today or don't have the means financially or the opportunity to speak against Zhao or Dr. Joel Joseph, that has consistently taken advantage unethically and professionally from people that own pets on Guam, like myself. On September 11, 2015, 2 of my dogs were victims of a horrible abuse by one of my ex-employees. Thanks to God, this individual went to jail for a few years, and now Guam has a new law in place to protect our pets. I began taking my pets to Zhao in 2019 while I was living in Tamuning, as Zhao was very near to my house. Our dogs never needed anything major besides vaccines and dog food and simple things. On September 11, 2015, after finding our dogs Rex and Lucky hurt, injured, and without being able to walk, I rushed my dogs to Zhao, and after some x-rays, I was informed by Dr. Joel Joseph that Rex 2 legs were broken and they needed surgery. I wrote a check for $1,450 on the spot so he can begin doing the surgery. After 5 days, Rex was released and I was provided with an invoice for the pay over $3,000 out of my pocket for the surgeries. Mr. Joseph indicated that all the numerous donations received and given by the community and businesses were applied towards my bill. So immediately I request from Dr. Joel Joseph a breakdown of all donations, and as I find out, a lot of people and companies donating funds, he refused to give me a breakdown. He indicated that all donations were already applied to my bill and that it was not necessary because he was giving me 80%. So that means that surgery costed over $40,000. I found that unprofessionally, willful, and an opportunistic behavior, as Zhao exploited my trust as a client. Zhao, Joel Joseph, indicated after the surgery that I was not going to be charged to change the gauze and spleen. He placed it on my dog's Rex, that he broke the leg in 3 places for the next 8 weeks. However, later on, he charged me $80 for each visit. Also, I questioned why Zhao, Dr. Joseph, was not being able to cast the front leg. And he indicated that that was the proper procedure and he was the veterinarian. During the passing of the days, I noticed that the rear leg, which it was with cast, it was getting stronger as the front leg, which it was on a spleen, was getting weaker, and he developed a limp. So I took Rex back to Zhao, and I informed Zhao, Dr. Joseph, of the situation. His response was that I needed to bring him every time to change the spleen and the gauze. Of course, that was costing me $80 every time. And I didn't want to pay $80 for something that needed to be cast. On October 6, 2019, I took my dog Rex to Zhao for a checkout, and I requested to Dr. Joseph that my dog needed to have the leg cast. However, he indicated that he was the veterinarian and the spleen was okay. Then he requested to have an x-ray done, which I agree. That evening, Dr. Joseph called me, indicating that I needed to open Rex's front leg again, that the pin was bent. And I requested how much it's going to cost me. He told me $350, and I told him to proceed. So I authorized him to proceed with the surgery. On Friday, October 9, and Saturday, October 3, 2015, as I was off island, as my mother passed away, my wife received a call from White South, indicated that Rex was ready to pick up. However, my wife informed me that White South staff was informed that I was off island, and they said that they will get back to her. On Tuesday, October 13, 2015, I returned from off island. And the following day, October 14, 2015, I went to White South to pick up my dog and to pay for the $350 that was agreed. To my surprise, I was handed a bill for the amount of $950. I noticed that the surgery bill was $350, but the overnight stay for 5 nights was $600, more than the hotel. I was never communicated that they were charging me for these stays, as it is usually part of the surgery. Keep in mind that this second surgery happened to the malpractice that Joseph Joel did to my dog to begin with. I asked for Dr. Joel Joseph, and I told him that I found my bill to be outrageous and unethical, and that I was going to pay what we agreed, so I wrote a check and I gave him $350. He refused to give me my dog. At that moment, I said to him, I will come back tomorrow, hoping that he will realize the mistake he's making, and I left. The next day, early morning, Joel Joseph delivered a letter to my office indicating that now he decided to charge me the 80% discount he provided me, which I have a discount for. So this individual, an ethical doctor, says, well, now I'm going to give you 80% discount. So if I add those numbers, this surgery will be costing me probably $50,000. If I break my leg today and I go to see any of these doctors, it will not cost me more than $10,000. The next day, early morning, Dr. Joseph delivered a letter to my office indicating that now he decided to charge me the 80% he provided me originally, and the amount owed to White South was not anymore $950. Now it was $2,673 plus the 80%. I felt outrageous, harassed, bullied, and that's when I find out that I cannot sue Joel Joseph for malpractice. Where we are, Guam. You cannot file a lawsuit against a veterinarian, a doctor that has done a malpractice. We're following laws that are 15 years ago. You go to school like myself, I am a real estate broker. Tomorrow, I advise somebody to buy a house, and that house has a problem, I am responsible as a real estate broker. I only had 3 years of school. These doctors, which are, most of them are my friends, and are great doctors, they went to school. They're supposed to be knowing what they're doing. Well, my problem here is not with the doctors, it's with this veterinarian. So then I find out that I cannot file a lawsuit. So now I need to go to arbitration. Let me explain to you how much I spent until today. $50,000. And on December 14, yes, on December 14, I need to come out with $24,000 more for arbitration.
All right.
Let me finish.
No need to
Senator.
yell. Let's
I am
just...
talking. I need to come out with $24,000 more. I already spent $12,000 with my lawyer, $24,000 and $7,000, $40,000 for an arbitration. This has to be fixed, Senator. Thank you very much. This has to be fixed. Okay, I am not raising my voice. I served in the military, 3
Listen,
tours.
I want to listen to, I want to
you.
get to the part where
Well,
you've
let
made
me
a
finish.
claim
I
and
served
what your
3
issue
tours
is with the
serving this
law.
country and
No,
defending
and I'm
the
not
freedom
going to
while
listen to
everybody
you.
were sleeping.
Mr.
Mr.
Bustamante.
Thank you.
Thank you. I want to listen to what you have
Thank
to
you
say.
very much.
We are here to do that, but I don't.
But
We don't need to be
frustrating.
yelled
It's so
at
corrupted.
for that purpose.
We should be ashamed. We are there to represent the people of Guam. I pay my taxes. I have employees.
Yeah, that doesn't mean you're going to yell at me, all right?
I am not
So you
yelling-
either
I am
calm
not
down
yelling
or
at
we're
you.
going to
I am saying
continue
that
this.
this is
Just that's enough.
I
We need to
understand.
just calm down. That's
I-
all I'm asking you. We are
Understand.
sitting here trying to listen to you, but I did nothing to you that you need to yell at me,
I
okay?
am not
So let's
yelling
just
at you.
calm down.
I am explaining to you this is
All right,
frustrating.
so get to the end of the story. Let's hear what is the issue with
Well,
the law.
issue is the
issue with the
malpractice
law.
that we're having. Is that okay for you? Now that you're being elected as a senator, is that okay with you?
Tell me what
What
changes
are we
do
going
you
to
want
do
to
about
see
it?
in the law?
What are we going to do about it?
What do you want to see changed in the law? That's
Thank
what I'm
you.
asking you for
Thank
tonight.
you. I tell you what, it's a lot of people right there, Senator Terlaje, they don't have money to stand where I stand to enforce my rights. It's people that they cannot afford a lawyer and pay $250. It's people that can afford 20, 30, 40,000 like I am. And you know what I am doing it? No, because I can. Because it's the right thing to do. I created a law to protect the pets. It took me to send somebody to jail. Now I need to spend over $40,000, $50,000 by the time I am done, in order to ask the senators and the legislature to create a law that would allow for somebody that has committed malpractice to pay for the consequences. I am talking about a pet. A lot of people say, well, it's a pet, No, a pet is like a son. It is to me. And a lot of people that has dogs, they will understand, okay? I hear right now Mr. Lepofsky that has a similar situation. If you went to school for 10 years, I went to Campbell University for 5 years, got my degree. I never had a lawsuit while I practiced real estate in Guam. Why? Because I know what I am doing. The same thing, you have to be held accountable to the highest standards. If you are a doctor or if you are a veterinarian. My thing, Mrs. Terlaje, Senator Terlaje, is that we can still allow veterinarians to commit malpractice, to do wrongdoings, and that person that owns the pet cannot take that doctor or veterinarian to court. Because now he has to hire a lawyer, $250, and he needs to go to mediation. So I decided to hire people from off island to be the mediators. $350 to $500 an hour. Mr. Mitch knows. I am here because we have to do something. I apologize if my voice is too loud, but as a citizen of Guam, as a resident of Guam that employ 10 employees and give work to the people of Guam, I feel that is the need that I have to raise my concerns. So you senators can try to enforce it and make it better. I heard that it's 20 cases plus that are sitting in the Ally Board doing nothing since 2005. My first complaint was in 2015. They stamped it, I did nothing until today. I've been carrying this case on my own. Finally, I spoke to Mrs. Sina, she's a nurse, and she has indicated that they hired Mr. Camacho to take over this. Great, fantastic. Guess what? Now, Mr. Camacho take his dogs to White Out. I want to point that to you. So we're working. I heard that we're working. I think it's great. But you know what, ma'am? I am the only 0.01% that can afford to do this. And I will go all the way because it's the right thing to do. Once again, thank you so much for your time.
Thank you, Mr. Bustamante. Can I ask you one question, or a
course.
couple questions? So first of all, you were told you had to do mediation or arbitration?
Arbitration, ma'am.
All right. And did you have a lawyer?
Jeff Cook.
All right. And the arbitrators that you chose were not from the AAA?
They are from
They
AAA.
are? Okay.
Yes, ma'am.
All right. Did you have questions?
Can we get a copy of your testimony, please? I don't think
yes.
we have a copy.
Yes,
You can
Senator, I will
with
leave you a copy.
The good ladies over there on the side.
Of course.
And, I also recommend that if you want to update it too as well, on suggestions and ideas where you think that might be helpful,
Thank
to
you.
give a balance as well. Okay?
I will.
Thank you.
Thank you very much.
To my staff, could I please get the Allied Health Board statute, please? Thank you. Mr. Thompson?
Madam Chair, I'd like to yield to Dr. Alfred. After her presentation, I may have something to add to it, but I think it'd be better if she went
Thank
first.
you. Dr. Alfred?
Chairperson Therese Terlaje and esteemed members of the 35th Guam Legislature, thank you for this opportunity to continue discussions on Guam's Medical Arbitration Act. This issue is very important to all people of Guam, including our healthcare professionals. Before I start, though, I'd like to recognize all the healthcare professionals who are here with us today, because I think we all find it important. If everyone minds, if they can please stand so we can recognize how important it is. It's very rare to get this many healthcare professionals in one room at one time on the island of Guam. And even the second floor is full of healthcare providers. We have held numerous meetings with the Guam Medical Association, the Guam Medical Society, the Guam Dental Society, and the Guam Nurses Association to discuss this very important issue. And we have spent hours brainstorming and looking at this issue from many different perspectives. Let me start by taking you back in time. In the 1980s, healthcare on Guam was not where it is today. It was nearly impossible to recruit specialists to Guam to take care of the people. One big factor in recruitment was availability of malpractice insurance. There was no malpractice insurance available to healthcare providers. Even if you wanted to, you could not purchase insurance. In the same way you would never drive a car without car insurance, many doctors would not agree to come to a place that had no malpractice. It also was impossible to recruit doctors because it would make it impossible to move from Guam. Malpractice insurance companies want evidence of prior coverage before you apply when you are applying for the coverage. Future employers also ask about your malpractice insurance coverage before they will even hire you. If coming to Guam would make it impossible to work anywhere else, physicians may choose to not come in the first place. There was a time in Guam when we did not have orthopedic surgeons. So if you broke a leg, you'd be in a lot of trouble. If you had a complicated pregnancy and delivery, you did not have an obstetrician to help you through your labor and delivery. If you hit your head and you had bleeding in your brain, all you could do was pray. Something had to be done. Dr. Eduardo Cruz, who was a surgeon, ran for legislature with the intent to solve the malpractice crisis that existed at the time. Through his efforts in the Guam Medical Society, the current Arbitration Act was made into law. At that point, insurance companies were willing to cover a small number of physicians on Guam. The Medical Arbitration Act was not implemented to protect doctors and other healthcare professionals. It was implemented to give people access to care and to protect the people's access to care. Since then, we have been able to hire and recruit many high-risk specialists on Guam. We now have orthopedic surgeons, obstetricians, neurosurgeons. We even have a half dozen interventional cardiologists. On top of that, we have dentists, orthodontists, physical therapists, speech therapists. These are all people who may hesitate to come to Guam unless they had some form of tort reform. Healthcare in Guam may not be perfect, but we are in a much better place than we were in the 1980s, prior to the Medical Arbitration Act of 1991. Why is this issue so important to healthcare professionals? First of all, it has allowed us to recruit a malpractice insurance company to write policy here. Prior to this, there was not a single company willing to come to Guam. However, even with this act, the cost of insurance in Guam is beyond what many physicians can afford. We actually just asked for a quote for surgery. It was over $100,000. This would take up a huge chunk of people's salaries, and they would not be able to continue practicing here. And because of this, the majority of physicians on Guam do not carry malpractice insurance. Second, this protects physicians from meritless lawsuits. What typically happens in a lawsuit is every single person who touched that patient gets named. If you were a night doctor covering the night shift and you went in and saw the patient because he had a fever and gave him Tylenol, you did nothing wrong. But a week later, if there was alleged malpractice, that physician gets named for giving the patient appropriate treatment at that time. But let's say it gets settled. Then now that physician has to declare in every jurisdiction they ever apply to, every hospital they apply for privileges, or every license board that they apply to or renew their license to, even though they did absolutely nothing wrong. Because of this, doctors often choose not to practice in regions that are known to be litigious, and this could potentially ruin their careers. This also applies to nurses, and nurses also get named in malpractice cases. If a nurse has to worry about tarnishing her license by working in a litigious environment, it would be impossible to recruit them. As in any field of medicine, nurses specialize in specific fields, and it is often difficult to recruit nurses in specialty areas such as ICU or emergency room. There is a massive nursing shortage all throughout the United States, and we have a worse problem on Guam. Our 2 civilian hospitals often do not have beds for the patients who need them. Let me clarify this point because I didn't quite understand that when I first moved here. So if you walk around GMH, you will see empty ICU beds, empty telemetry beds, empty beds that are in the hospital. I used to ask, this is dumb. Why are these beds empty and yet they're saying that there are no beds? Well, it's not a physical bed shortage. It's a shortage of nurses to take care of those beds. You cannot have a patient occupy it if you don't have someone to take care of them. Without this arbitration law, it would become even more difficult to recruit nurses to staff our hospitals and take care of our sick. In public discussion, doctors have been accused of being apathetic, not caring about patients, being white coat killers, and only caring about our bottom line. I can tell you this is absolutely false. I do not know of a single healthcare provider who went into the health profession to harm people. We all went into this profession to help people, to care for the people during times of health and times of illness. We spend many years in school, followed by many years of training, to be able to do what we do. Schooling and training are rigorous. We would never, ever survive it if we did not have the passion to care for people. On top of which, Guam is a small island. We know that the person we're caring for is a member of our family, our friends, our neighbors. We know we're taking care of someone's mother, father, brother, sister, friend, coworker. Our hearts are all intertwined on this island. It is a huge responsibility that we bear. We also do not go into this field for money. Many of us are saddled with enormous student loan debt. Doctors and dentists walk out the doors of school with as $250,000 in debt easily, for some cases $900,000. Some people are stretching $1 million in student loans. This is before we even start working. There are many more fields we can go into that do not require the length of education that we have to go through. There are also many more fields that we could enter that would be significantly more lucrative. We also don't make that much more money. Nurses on Guam make so little, if they were to decide to move to the States, they would make easily triple that. Doctors, dentists, physical therapists, we all find the same. We all have our reasons for coming to Guam. For some of us, it's home. For others, it was an adventure to live in a faraway island. But we all stay for the same reason, our love of the island and its people. Guam is a unique place. We are part of the United States, yet we are on the opposite side of the planet. We have many challenges that are unique to our island. Despite improvements in care, we are still far from where we would find at big university hospitals in the United States. We lack many specialists. Even if we have the specialists, we lack the equipment or the specialized team members so that these specialists can provide care. We often discuss scope of practice for physicians here, and our scope is often much more broad here than would be in the United States, as we do not have the specialists available, and flying distant lands is often not an option for patients. On top of which, we have to deal with many of the social barriers that patients face on this island. If you're working 2 to 3 jobs, going back and forth, or you're going between job and elder care and child care, when are you going to find time to exercise? When are you going to find time to grab a healthy meal? A quick meal usually does not equate to a healthy meal. I have patients who can't access their medications. They didn't have the transportation to get to the pharmacy. They don't have the funds for their copays, or they're just so busy between their 3 jobs and they can't take enough time to get to the pharmacy. The big thing that GMH faces is when patients need care off island, the patients don't even have passports. And even if you expedite the passport, you're easily talking about waiting a week to 2 weeks before you can transfer them off island. These are issues that are often out of our control, yet affect patient care and our ability to take care of them. Despite all these difficulties, we try our best. We are not perfect, and I do not think any single one of us would ever claim to be perfect. We are people too. We are human beings just like everyone else. We all make mistakes. We try to learn from our mistakes so that we never repeat these mistakes. We are constantly learning, talking with each other, discussing treatment options, reading, going to conferences so that we can be as good of a doctor as we could possibly be. I want to take a minute to acknowledge Mr. Lepofsky, who lost his son Asher. I also want to acknowledge all the members of the community who so bravely spoke about their experiences. This helped to start a dialogue among the medical community of Guam, and for that we really appreciate it. We need to be able to help improve access to care while helping people have a voice. We agree that there should be some sort of safety net for the community in the case of medical malpractice or negligence. We still believe arbitration is important for several reasons, but we acknowledge the cost of arbitration is a huge barrier for many people. Medical arbitration is not cheap. We've heard many testimony about this. It could be in the tens of thousands to over $100,000 between filing fees, arbitrator fees, lawyer fees, expert witness fees. This can dissuade someone from filing a malpractice claim. Not having the financial means to file a malpractice claim should not be a barrier for people who have been affected by medical malpractice or medical negligence. Because of this, we propose an Access to Medical Arbitration Fund for people who wish to file a malpractice claim. This fund would be used for the sole purpose of assisting a petitioner with the cost of arbitration filing fees and arbitrator fees. This fund shall be administered by the Office of the Attorney General. A portion of our licensure fees from every single licensed healthcare professional in Guam at initial licensure and renewal would be deposited into the fund. The government would contribute an initial matching amount, about $100,000, to help set up the fund. Criteria would be set for those who qualify for assistance from the fund based on income or asset limits, for example, based on MIP eligibility. Application for assistance would be submitted to the Office of the Attorney General, and the petitioner would agree to participate in good faith in a review of the claim by a hearing officer as designated by the Attorney General. The hearing officer would issue a certificate of qualification that the claim has a reasonable probability of success on the merits. The hearing officer would consider evidence and materials submitted by both the petitioner and the healthcare professional. They may also consult with members of the Professional Licensing Board for the respondent health professional in making such determination. Neither the issuance or non-issuance of the certificate of qualification shall be admissible during the procedures. If assistance is approved and the certificate of qualification is issued, the fund shall pay the filing fee for the arbitration and/or the arbitrator's fees directly to the association or arbitration service provider. A lien in the favor of the fund in the amount of all assistance provided would be created against any settlement, award, or judgment, which would be paid prior to any disbursements of such proceeds. We hope you consider our proposal. We hear the community's complaint that medical arbitration costs is insurmountable for many. With a fund created and funded by healthcare professionals for those who need assistance, medical arbitration will not discriminate against those who cannot afford the filing costs and the arbitration fees. We feel that the medical arbitration law should stand. Guam is a very unique place. We are a small island in the middle of the vast Pacific. We are also still a part of the United States. It is difficult to recruit and often even more difficult to retain healthcare professionals, even under the best circumstances. If Guam becomes a litigious society and medical malpractice insurance becomes unavailable or cost prohibitive, as it already is for some, then we may not be able to recruit physicians to come to Guam, whether they are from here or not. We may not be able to retain those that are already here. Many people have said they would have to seriously consider moving. Even worse, we have a massive nursing shortage. Hospital beds are closed because there are not enough nurses to take care of patients. This is a reality throughout the United States, and even a harsher reality for Guam. This discussion affects every aspect of healthcare in Guam. Senators, please take into account the big picture and consider far-reaching consequences of repealing the medical arbitration law. Please consider our proposal, as we feel it will offer protection to patient access to care. Thank you.
Thank you, Dr. Alfred.
Good evening, Dr. Alfred. For the record, you're my doctor. I just wanted to make it clear to everybody. I did, what you were reading actually was something that somebody gave me, that same thing that you're reading about, the suggestions. And, I brought it to some of my staff and people who've been studying with this. And the question that kept coming out was, why is it that the government of Guam needs to fork out $100,000 when these doctors have private practices? We have a government claims act that handles for the hospital. So my question to you, are you amenable to at least providing a fee to doctors who practice on Guam yearly to fund that fund instead of using government of Guam funding?
A big part of it is it's just a seed fund for $100,000, but every time we renew our contract, we would be the ones funding it.
It's just seed money? That's what you're saying?
Correct.
So
it's
then,
seed money.
so
And
you're
so
thinking $35, the amount of $35 on the fee will be enough to cover $100,000 a year?
correct. We did the math. I forget the actual number, but when we multiplied 35 by the total number of healthcare professional licenses on Guam, it ended up $100,000.
If I'm not mistaken, there are about seven or five cases a year. And if you have that many a year, that's not even close to, 100,000 would be wiped out with just 2 clients.
Senator, if I might butt in response to a question from the chair, I checked with the AAA as far as the number of arbitration cases that had been filed with AAA over the past 5 years, and they confirmed that there was a total of 3.
But if I may interject here, the reason why there was only 3 is I heard that other people just could not afford it and never filed. But there are several cases out there where people had to just turn their back because they didn't have the money. And that number came up to about 7.
Because we are looking at cases with merit, this is why we thought that the Attorney General's office would be a good office to use to determine whether the claim has merit. And just because you want to file a claim does not mean it necessarily has merit, which is why we're going to have a gatekeeper of the fund, because we can't let it be a free-for-all. Like you said, the fund would run out of money quickly. And what would happen is we have an initial fund. Every time we renew our licenses, we would put in an additional, and the $35 is just, a point to start, just because we thought having $200,000 initially in the fund would be at least reasonable. Now, if the claim does not have merit, in the light of the hearing officer, they just do not have access to the money in the fund. They also have to meet specific assets. If it's someone who has a lot of assets and a high income, they would not qualify for this, because this is meant specifically for people who cannot afford to go to arbitration. And there is also the last statement where we would put a lien on any money that was dispersed so that it can be put back into the fund, so that it regenerates the fund each time.
Yeah, keep going.
And it's hard to imagine that there would be 7 simultaneous cases. So, and because the nice thing with arbitration is it's a lot quicker than going to a big, long trial, hopefully the arbitrations will be finished and the funds would be regenerated before the next person would have access to it.
And Dr. Alfred, if I'm not mistaken, these are some of the suggestions for it, but to maintain the current law as it is, not
Correct.
to amend it at all, but only to include these options for individuals, you know, and plus creating the fund itself. But your suggestion is not even to touch the current law.
Correct.
Thank you, Madam Chair.
Thank you, Dr. Alfred.
Thank you.
Good evening, Senators.
Good evening.
Thank you for the opportunity for allowing me to speak. My name is Dr. Mo Ping Tom. I am a double boarded in family practice and osteopathic manipulative treatment. I've been here 5 years in Guam. I was hired to come here by FHP Clinic to work in their urgent care. As far as I'm aware, I'm the only physician, osteopathic physician in Guam who's practicing osteopathic manipulative treatment on patients here. Just to give you a little background about myself, prior to coming to Guam, I was an assistant professor at the University of North Texas Health Science Center at Fort Worth Medical School, where I oversaw the training of medical students, interns, and residents. Before I came here, I had many opportunities to further my career. I could have chosen to stay at my medical school. I was also offered a job to work at a medical school in New York. I was even offered a position to join a private practice in New York City. So for me, I had many options, but I chose to come to Guam out of my own desire to be here on this island, enjoying the island life. But just as I came here by choice, if the environment becomes more litigious towards doctors and people practicing here, I could also easily choose not to be here. And I just wanted to speak to you a bit about the issue with recruiting doctors here on Guam, because I know it's been brought up a few times before. It is difficult to recruit doctors to come here. In the past 5 years that I've been working here, I've seen 13 providers come and go in my urgent care department. Locums tenens doctors were hired as a stopgap measure until full-time permanent doctors could be hired. The ones that were hired for full-time positions with the company chose not to renew their contracts when their contracts ended. Not only is it hard to bring people from the mainland to come here, but once here, it's hard to retain them after their contracts expire. The challenges of retaining doctors can be numerous. They don't have ties to Guam, their families don't like living here, they move back to be closer to family, or they just don't like the weather, or when somebody in North Korea threatens our island, it freaks people out. So there are reasons for why it's difficult to get doctors to come here. If malpractice rates increase and the cost to practice medicine goes up, clinics will have to spend more to cover the cost of malpractice insurance. And ultimately, they will pass that cost on to the patients in the form of higher premiums and copays. The higher malpractice rates will increase barriers to physicians coming to the island, for clinics to recruit physicians from the mainland, or for those already here and wishing to open up their own practices. It's a lose-lose situation for all involved. Thank you.
Thank you, Dr. Tam. I think we have one more person signed up, Annalyn Lagramas. If you don't mind staying for a few more questions. Oh. Yes. Oh, I called you earlier. Please, yes. Was there anyone else who had signed up earlier who intended to testify? Okay. Oh, wait. Turn on the microphone, please. And yeah, thank you. State your name for the record.
All right, thank you very much, Senators Taitagui and Terlaje. My name's Stan Yasuhiro. I'm a dentist here. Been practicing here for over 36 years. It's been a home since 1964. Thank you. Basically, it's home. I was very much puzzled about why this arbitration situation was becoming such a big issue. And in reviewing the way things are being done as far as malpractice or any kind of disagreements, I had to fall back to my experience. I'm a former chairman of the Guam Dental Board. I am also a two-time past president of Guam Dental Society. Over 25 years of international liaison for Guam Dental Society and the World Dental Federations. And so I was able to kind of look at both sides of this situation. And there are things that can be done. There is a lot of talk about arbitration, so I'm not going to even kind of get into the pros and cons of that. But I'm going to kind of bring this down to our local level. From what I'm seeing here, there are a lot of frustrated patients. There are a lot of frustrated people against the healthcare community. And some of it is misunderstanding, and some of it is outright bona fide problem. And I think that the other issue that we have is having proper practitioners on this island. So if we're going to expect proper care on this island, we need people that can practice properly. We need good people. We need good healthcare providers. And in order to do that, we have to have a strong regulatory body, which we don't at this time. And we don't at this time the HPLO office, the Health Professionals Office. And I don't fault the individuals that are running the office. Actually, I have to give my hats off to them because they are trying to do their best with the very little that they are given. There is no priority given to the HPLO office, which is probably affecting almost everybody on this island. It's one of the most important regulatory bodies on this island. And right now, there are people that are doing their best, trying to work things out, and with all the complaints that are coming in, there's just not enough time, there's just not enough money, there's just not enough energy to get through all this. And they're handling medical, nursing, dental, allied health, they're handling everybody. And this is absolutely just ridiculously kind of cruel, actually. And the support that they need has to come from this body, the legislative body, in the form of a proper budget. There has to be support from the public health office in the way that they need to give them priority. And we have to, as a group, sit down and take them seriously. We've had situations where dentists came on this island seeking to get a license. Sad to say, I have seen cases that were just totally ridiculous. And I don't know why they even attempted to get a license here, but they were told by their recruiters that, oh, you won't have a problem. You'll get a license. And when we failed them, we received a lot of criticism. And there was even an instance where the Guam Board of Licensure was threatened to be disbanded. This was several years ago by a legislature. And so, you know, I think that's the area that we need to work at, because it is the premier regulatory body. Now, in the process of a complaint, we need to go through the hearing process with the hearing officer and the attorneys from the Attorney General's office, as stated and mandated in public law. We should not and cannot have our private attorneys. They have to be appointed through the AG's office. Then, after that is done, then they can go ahead and the parties can accept the recommendations and settle, or they can go ahead and go take it to court. They can go through the arbitration, and perhaps the discussion of coming up with the proper funding for that may help that. But we at this time, our hearing process, in my opinion, my personal opinion at this time, I think is broken. And I think that needs to be fixed. So, you know, people such as Mr. Lepofsky and his family have a way of getting some type of resolution from this tragedy. And so I think that we need to kind of work with the system that we have right now and fix it. And so I'm not going to go into detail at this point, but if you'd like, I'd be happy to make any input on that. Thank you.
Dr. Yasuhiro, you are a breath of fresh air, and I want to thank you and it's very timely because I do think there's been just very recently a new focus on the HPLO, the licensing office for all the all the healing arts, for all the medical, the nursing, and the allied health, all of it, and exactly what you've pointed out. So. And that was also one of Mr. Lepofsky's initial complaints, was that his initial complaint was not handled quickly, and some of the Allied Board complaints are not yet handled. But so the good news is that, yes, new focus on it. I want to thank the Director of Public Health that she has prioritized this. They have dedicated already, sent out RFPs, and for some of these things, they have to renew the hearing process. So. Hearing officer from the Attorney General, prosecutor hired by the boards or the HPLO office. They're going to hire investigator and an inspector for all the boards to share at this point. They are making they have a renewed interest in their funds, obviously, in order to fund all of this. So you might be in your respective professions seeing some requests for increased fees. They're going to look at fees and the funds. And I have promised to make sure that the original intent of the statute, where all the fees for your field go to the board for that field and are utilized for regulation as it was intended. And I think the regulation is what you're describing. We have strict criteria, and we need to enforce that.
I just wanted to mention right now that all the funds are going to the public fund.
Right, that's the
general
complaint.
fund.
So that's what I'm saying. It's they're supposed to be allocated to the boards, and we're going to ensure that that is happening. So, so that everybody can be satisfied that the fees you are paying are actually used for the purpose of regulating your field as they're supposed to be, and that the patients can be satisfied that they are going to get that due process, or that process that they've been asking for. And so you're correct. There is a big disconnect in that area at this moment, but thank you for that. All right, thank you very much. All right, I had a couple questions. So on your proposal, well, Mr. Lepofsky, one of your alternate proposals, now not the original proposal to repeal the entire statute, but in one of your alternates, you discussed extending the time period in which to file up to 3 years. Right now, it's 1 year in some cases, and up to 3 years. And did anyone else have anything to say about that proposal? The 1 year is a little bit problematic because if you go through arbitration and it takes a while, that 1 year is your deadline to also file in court. So I think what you're looking for is a way to also file in court, have some time after the arbitration to decide whether you're going to continue in court or not.
Also, in most states that I looked at, it was 3 years. And during the first year, there were some things that I discovered, or that we discovered, wasn't towards the end of the first year that impacted our own case. And it took about a year to try to get information. So the first year, through everything that you're going through, things come up. So for sure, 3 years, and that's what most states have, from what I understand, is 3 years to file. And I think it's fair. Why not? And sometimes, if somebody's injured in the first year, the ramifications of that injury is not really known until the second year. They've been injured, they don't do anything, and finally they find out, oh, you have this serious problem, but the 1 year's already passed. So it allows time for the ramifications of an injury to be defined.
Thank you. All right, and then the proposal to have a fund that will help patients who want to make a claim or go through arbitration to be able to afford those initial costs of arbitration, and that the fund would be reimbursed if the patient is successful and receives an award in arbitration, and they would reimburse that fund. All right. Mr. Keogh, did you want to say anything regarding any of these proposals? There were other proposals that are on the table. If I could just read them, there's the short list. So those are a couple. One was to, of course, one suggestion was to make sure that we don't have to use one single provider for arbitration, the AAA, and that we can have many alternatives, or any alternatives that the party can decide. Less expensive alternatives was, I guess, the goal, right? So instead of a 3-panel, perhaps a 1-panel. Those were some of the suggestions. To be able to get arbitrators that might be less expensive from different areas. That was another suggestion. The assistance fund. When the suggestion is made to repeal arbitration altogether, there were also some other suggestions that if you repeal arbitration, put something else in its place. And this is what we've seen in other jurisdictions. Not always very satisfactory either, because in some of those we have a screening panel, so that's a proposal that's on the table. A screening panel where they are going to screen the merits of the case, and then you go to court, or a caps on damages is kind of the trade-off that we've seen in some other jurisdictions, where they repeal or they don't. You can go straight to court, but they're going to cap what you're going to be able to receive. Changes in the statute of limits is also on this list. A more transparent claims process, and I'm hoping to solve that issue through this HPLO board, that complaints to the boards are dealt with efficiently, and we can't, well, I'm not sure. I haven't heard exactly a proposal of how to make an arbitration process transparent, to show the parties, but still, that's possible, I guess. Island peer review of claims. I think this is kind of what these boards were set up to do. We have boards for each field that's supposed to be comprised of members of your field, and they're supposed to be the ones who are reviewing claims at that level at least. And then there was some ideas for caps on the government claims. So these are claims against government physicians. And that there's also been a suggestion that the claims against doctors practicing at the hospital in particular, because it's a government entity, that those should be more public, and that we should. But I think that the hospital, this is something I have to admit I haven't looked into too much, but I will. I believe the hospital is also supposed to have its own review process and to be able to address that type of concern right there. Yes, Dr. Yasuhiro.
If I may add, on the HPLO level, we do need some dialogue with the Attorney General's office. I don't know about the current administration, but in the past, there had been backlogs. There wasn't really much of a priority on these kind of situations, and so I think a little dialogue with the Attorney General's office is needed. Thank you.
Thank you. Yes, I think that is happening, so thank you very much. Mr. Keogh, did you want to say anything? And I know that we have Annalyn Lagrimas. If you can have a seat, you allow you to testify. One more testimony, and Mr. Keogh, Attorney Keogh.
Yes, just briefly, I think you have just put your finger on the most difficult problem here, and that is the American Arbitration Association. Just to file your case, your filing fee is based on what you assess to be the value of your claim. If you put no value on your claim and let it be determined by the arbitrators, it's a $10,000 filing fee just to file the case with them, not counting the cost of the arbitrators and everything else that goes along. You file a case in court, it's $300, regardless of whether it's worth $10 million or $10,000. The American Arbitration Association is just incredibly, prohibitively expensive. Arbitration in and of itself is not the culprit, it's the expense that's involved in it. That's the problem that has to be addressed. And there is no other local alternative here. I know Mr. Thompson has mentioned PAMS. He's a principal in it. If he's representing a party, you can't have that party arbitrate a case where their opposing counsel is the one who owns the company that's arbitrating it. There's nobody else. So somehow some process has to be created where the claims can be heard less expensively. Before I came here 42 years ago, I practiced law in Pennsylvania. Every lawyer, in order to be licensed in Pennsylvania, had to sit on an arbitration panel and listen to cases that would be decided. Any kind of negligence claim had to be screened by an arbitration panel. It was usually just a one-day process where each side presented their claim, and it was decided whether or not the claim should go forward or should not go forward, and there were penalties if you went forward and it was determined that your claim was not meritorious to begin with. That's the kind of process we need here. Something like you're talking screening panels or something. This is not, the issue here is not, as I read in one of the testimonies, the written testimonies, the solution is not to attack hardworking doctors. I don't think anybody is here to attack hardworking doctors. Nobody's here to attack anybody or anything other than the process to get a legitimate bona fide claim heard and decided. That's what has to be addressed.
I appreciate that. Thank you.
Thank you, Attorney Keogh. What do you think about the caps?
Caps, I did talk about caps a little bit the last time, was when we had an example of a case in Kansas, I think it was, where a person was quadriplegic as a result of an injury, a 17-year-old boy. The cap was $250,000 for his non-economic, his pain and suffering. Spending a life suffering from quadriplegia, I think anybody would acknowledge is worth more than $250,000. I'm not talking about economic damages, but the non-economic damages. Caps are very selective and arbitrary, and all that does is keep insurance costs down. There has to be a better way to do it than caps.
I agree. I don't want to see a trade-off for patients who want to seek some type of, justice that they have to be limited. So I think in that regard, our arbitration law or our law right now, having no caps is such, it's good. All right. Did you want to say something else?
Just to reiterate, the arbitration process in the current law is not prohibitively burdensome. I mean, it's just similar of going to court. It's the same thing,
right.
Only you have to pay for your judges. And pay for the administration of it. And that's where it ends up costing $50,000, $60,000, $70,000 to have your case heard through the arbitration process. It's the expense of it that is unfair and burdensome.
Attorney Keogh, you had an opportunity to look at another type of coverage, and it's the screening panel. And in the screening panel, it has three members. I think it was 2 doctors and 1 attorney. in the screening panel process. Do you recommend, because the cost, we're looking at the cost, it's very difficult for doctors to be, judgmental against their colleague. Very difficult for that. But do you think that this screening panel should what should be the makeup then? Any idea other than putting another doctor on there, or the Allied Health Board? We were talking about that, and they're held to a certain standard too, to be to scrutinize doctors as well, regardless if it's doctors coming in or doctors that are here right now. They hear cases a lot of times. I mean, one case was the Joel Joseph one that they heard. So do you think that it really is such an issue to have at least one doctor on that screening panel from Guam and then a couple attorneys? Your suggestion on a makeup of that screening panel is appreciated.
A screening panel can be a wide variety of different makeup of how it's done. To me, the most effective screening panel we have are Superior Court judges. They can screen cases. That's their job, and that's what they're paid to do. We have them already. I haven't seen the evidence of malpractice crisis here on Guam. It doesn't happen all that often. But some kind of process to screen the cases, as long as it's not costing tens of thousands of dollars to be able to do that. Mediation is a means of having your claims assessed by somebody who's impartial to it, but it's just the expense of doing that that's the problem.
Thank you. We've also received testimony from Health Services of the Pacific. It looks like a Dr. Schroeder and Dr. Lee. And all right, Ms. Lagrimas?
Yes. Dear Senators, I urge you to repeal the triple MA or reform it because it does not serve the people but protect a select few. Arbitration law is unclear with no expert witness on Guam, since local practicing physicians won't investigate or determine fellow physicians' malpractice, negligence, or medical error. We cannot and must not turn a blind eye on the negligence and malpractice that does happen and not determine them baseless or without merit, without court litigation and a proper investigation. No one deserves to go through the errors of medical care that could have been prevented. No one deserves to have never events happen to them because it's not seen as a big matter or the patient was sick in the first place, so it wouldn't matter if something like a stage 4 hospital-acquired bed sore developed that can cause to death. No one deserves to be treated indifferently due to sickness, determining that these never events happen because the person was sick. If that was the case, why don't insurances cover it in the first place? CMS denies all payments associated to never events because of the medical error. It's unnatural to have something preventable develop and form to a critical state in a hospital setting for more than a month, going unaddressed. Everyone is prone or at risk of getting sued, be it any regular worker, a law enforcement officer, businesses, industries, contractors, and even our own government. So why is it only a certain group or profession exempt from the court of law? Laws can be made to fix the shortage of medical professionals, like the NLC or funding medical scholarships, but not by hiding negligent malpractice. Instead of hiding the mistakes, the negligence, and the preventable deaths that hurt the community by forcing a roadblock through arbitration, we should focus on inspiring, creating, mentoring, and generating new laws. We need to pursue these sustainable options rather than the option to have those affected by negligent malpractice go through tremendous suffering. There's no liability for the patients, who suffer through medical errors. The cost of long-term treatment as a result that can also lead to further disability should also be addressed. Physicians who lobby the MMMA are more concerned about their malpractice insurance increasing than they are of the people who go through the pains and sufferings of medical error. When they swore to their medical profession, they were all aware of the possibilities of lawsuits. It's not like they graduated medical school granted protection or immunity. Guam arbitration grants them that because of the lack of resources to even go through the arbitration process. Some of the suggestions I have listed down here would be like creating caps for malpractice insurance or mandatory mediation. That's all. Thank you.
Thank you very much. Mediation is a viable alternative in other places. The issue again is how is it structured and what's the cost? It's very similar in many ways to arbitration in that we hiring somebody to do the mediation or somebody to do the arbitration. But thank you very much, Ms. Lagramas. Is there anyone else who would like to testify before we end this hearing? Like I said earlier, I'm going to send my summary of these proceedings, and all the testimony that has been provided is going to be forwarded directly to all the senators. It will be put up on our website, so everyone has an equal opportunity to craft whatever legislation it is that they might want to. You are always welcome to send anything you want to me. I'm going to do my best to try to address whatever it is that your concerns are, and but I know I need your help. I'm going to need all of your help in order to really get something that's good for the entire community. We need to make sure that we do this going forward, and we want, of course, I know all of you want the best health care that we can get here on Guam, and we haven't lost sight of that, so that is our pursuit. And I want to thank all of you for your testimony and for the time that you have spent trying to ensure that we hear you, and we have heard you, or at least we have heard you, and we're going to do our best. So again, thank you. Is there anyone else who would like to say anything? If not, I will ask Senator Taitagui. Any other words?
This is the last of 3 public hearings we've had, and I greatly appreciate everyone who's here, especially those who've been through a trying time, a very difficult time, and Annalyn being here again. I just really appreciate you coming here all the time. I know you're taking care of your father, and what you said about, I appreciated your testimony. It's different from the last time, so if you can please email that testimony to us. You made some good points there. And thank you to everybody. I want you to know, as far as I'm concerned, you know, I've been studying this for a while now, and for me, it's about a balance. It's a balance for everybody, as well as our doctors, to ensure that we have good care on this, more than a standard of care, but an excellent care of health on our island. So I greatly appreciate it. And to my staff, just a little shout out. I grilled them on this, so they did a lot of research on that too. I just wanted to say thank you to Sandra, who's sitting over there, who's done quite a bit of research. Thank you so much.
Thank you again for everything. Si Zusma. See, the hearing is now ended. It's about 6:40 p.m. Thank you.